So maybe we could start the meeting because we do have a full program. I know people might still be joining us, but perhaps we could already open the meeting. So just for those who don't know me, I'm Simone Cuomo, the Secretary General of the CCBE. So we have been organizing this workshop, in particular for our membership, to be informed about different funding opportunities available at European level. I would like again to ask you to unmute, to mute your microphone to avoid noise interferences during the presentations. Yes. Yes, I think this is better. Okay, thank you for joining us. So just for the Commission, we do have participants from various countries from our membership. I mean, yes, we do have people from Denmark, Austria, Belgium, France, Germany, Greece, Hungary, Ireland, Italy, Lithuania, the Netherlands, Poland, Slovenia, Spain, UK. So, and I'm sure I'm still missing some countries, but it's quite an international audience here. So I would first like to give the floor to our Vice President, Panagiotis Perakis, to open the meeting, and then we can start with the program. Panagiotis, floor is yours. Your mic.
Yeah, thank you, Simone. Dear colleagues, thank you very much for your interest and for your participation in this workshop on available EU funds for bars and lawyers, which is organized with the kind support of the colleagues from the European Commission. As some of you may remember, a few weeks ago during our standing committee meeting, the Deputy Director of DG Justice, Peter Csonka, provided a very broad and extensive presentation on the new judicial training strategy adopted in December 2020. We were informed that one of the numeric objectives of this strategy refers to the number of trained lawyers on EU law issues. Namely, the European Commission states that continuous training on EU law each year should reach 15% of lawyers by 2024. As the CCB, we assume that the objective of this 15% of lawyers is a very ambitious target. However, we are ready to assist and motivate our member bars to pay particular attention to the continuing legal education.
Panagiotis, I think there is an interference. No, I think we lost Panagiotis. Yes. Okay, let's try to get him back. No, I think unfortunately we lost Panagiotis, the connection, I think. So Panagiotis, I don't know if you hear us, but if you could otherwise refresh and join us again, otherwise we will have to continue. Yeah, no, we lost the connection with him. Okay, well, I think, yeah, we will then unfortunately have to continue unless he is able to reconnect. No, fortunately he cannot reconnect immediately. So, well, then we will continue the meeting. So I see we now have reached almost 100 participants, so that's very good. So first of all, I want to also inform you that we are recording this session because the Commission has given also permission for that. So we will record this session. Just to bear that in mind, if you make any intervention, that it will also be recorded. So we do have a full program, which you all have received, and so we will have three main sessions, and these are started by presentations, and then there will also be an opportunity for questions and answers. Now, we of course realize we do have a very full house of many people, so we will see how we will run this question and answer session. We will see how many questions we will get in. In principle, so the way to ask a question is to push the raise hand button, and then we will see if there are too many raised hands. We will unfortunately only be able to address a few, obviously, because for time constraints. But we will see how that goes. So thanks again to the Commission for their initiative and availability to do this workshop. And I would first like to introduce to you then Dovile Weigerscheite. My apologies for the pronunciation, Policy Officer at the Commission on the unit dealing with, among others, the EU Recovery and Resilience Facility. So please, Dovile, the floor is yours.
Thank you, Simone. And before I start, and I'm sorry to intervene with your chairperson's role, but I see that Panagiotis has joined us again. If you wanted to give him the second opportunity,
yes.
And I'm happy to wait.
Yeah. Okay, thank you.
Yes.
If you can, yes, because we lost you. Yes.
Yeah, I was talking about the two pillars of funding the two main pillars of today's workshop: EU Recovery and the Resilience Facility and the funding opportunity under the Justice and the Citizenship, Equality, Rights and Values programs. It should be noted that today's workshop will cover more broader topic. Not only available funds for the training of lawyers, but also for digitalization of justice, promoting judicial cooperation in civil and criminal matters, e-justice and access to justice. So to go faster, I wish all participants a very interesting workshop. It is a great possibility for us to learn today. I also would like to express my gratitude to the colleagues of the European Commission for their time and for their availability today. We are at your disposal to support this effort. We would like also to find the ways to facilitate the local bars to achieve the funding and the training that they must have, and we all wish to have. So finally, I would like to thank Simone Cuomo, who is the new Secretary General of the GCB, and Indra Bule for the preparation of this workshop. So thank you. I'm sorry for this technical problem, and we can start.
Great.
Thank you, Dovile.
Thanks. Thank you. So Dovile, please.
Thank you. And first of all, thank you so much for giving the opportunity for me to come and speak to so many people from so many different countries. And I was asked today to present the Recovery and Resilience Facility and what can it do for the justice systems, obviously, as this is your topic. And I have some slides. And before I start, I just wanted to also say that of course, the event was facilitated by our colleagues from DG Justice, and I come from a Secretary General Task Force on the Recovery and Resilience, which is another department of the Commission, but I am also accompanied by a colleague, Andrea Tiquero, who follows digital aspects, so she'll be available also together with me to answer any of your questions after the presentation. So let me quickly load my presentation, and let's hope the technology cooperates today with us, as you can never know. There you go. Can you see my slides?
Yes, perfect.
Very good. So actually, to start with, the personal remark is that tomorrow is going to be exactly a year when I was sent from my office to be in quarantine because one of my colleagues was diagnosed with COVID. And I was luckily one of the 20 people who attended the meeting with him. So that's my personal experience with the pandemic started. And it's difficult to believe that it's already 1 year. But here we are. But on the other hand, I think this experience for everyone was also about discovering silver linings in that there is nothing, there's always some good in something bad, as we like to say in my country. And why am I telling you this? Because I think the Recovery and Resilience Facility is kind of a silver lining in a way, because it started as a response to crisis, but now it is serving to advance the EU's priorities that were identified at the beginning of this Commission's mandate. So there's nothing bad that doesn't have certain good in it. So today I will talk about the facility, what it is, and how does it function. And then I will also quickly touch upon, so what can it do for the justice systems and the justice systems reforms? After me, there will be another intervention by a colleague from DG Justice who will talk about more digital aspects of the justice system. So I will try not to preempt his presentation. I will not go too much into detail on that aspect. So let's start. What is the facility, or as we call within the Commission, the RRF? So a year ago, we were all faced with a crisis that came out of nowhere, and suddenly the Commission and the national authorities were faced with a crisis management. So it was a reaction to the crisis, and there were lots of measures adopted starting from March last year. How do we cope with all the implications of the crisis? So there were lots of measures being adopted. I'm not going to go through them, but it's a big monetary-wise response to the crisis. Now we are entering now another phase of dealing with the crisis, is how do we recover from the crisis? And this is where the RRF comes into play. And the RRF is part of bigger response from the EU to the crisis, which is so-called Next Generation EU. If you have ever been in Brussels in the past months, well, it's a bit complicated with a non-essential travel ban, but there is a big banner on the Berlaymont building already for a while saying Next Generation EU. So this is like a slogan for presenting what is the EU doing to recover from this crisis. And this is where the RRF also comes into play, because it is part of this Next Generation EU package. So the Next Generation EU will function together alongside the multi-annual financial framework on which the agreement was reached last year, and both together will serve for the coming years to take the EU out of this economic and social crisis. And the centerpiece of the Next Generation EU is the Recovery and Resilience Facility. So what is it, the RRF? The RRF is a big envelope of money, and it is really big since it's 672 billion euros altogether, that will be made available to the member states for the coming 5-year period to adopt measures to address the issues that were caused by the crisis. Now, an important element to note is that not all the member states will get the same amount allocated from the RRF. Those that were affected the most, member states, will get a bigger chunk of money. And that is not depending on the Commission. It will not the Commission who will decide how much each member state should get. It was established in the regulation that came into force very recently on the 19th of February that established the facility. So the work had already started on a political level and on administrative level to prepare the facility, but formally it came only into force a few weeks ago when the regulation was finally, when it has finally entered into force. Now, what makes it different from the other funds? And quite often in our dealings with the member states and stakeholders, we see that the RRF is quite often confused with the cohesion funding. Here, there is a big difference in that this facility is a performance-based facility. So it will be made available, the payments will be made periodically on the basis of achieving the results. Now, what kind of results are we talking about? So apart from the objectives of the facility that you can see in a bracketed box, which is promoting the cohesion, strengthening the resilience, mitigating the social and economic impact of the crisis, and supporting the green and digital transitions, apart from these, we also, the member states will also have to address the challenges that were identified for that specific member state. Sorry, is someone sharing the screen? Oh, sorry, no. You see my presentation still?
No, indeed. Sorry, I think indeed someone is sharing a screen. I don't know how we could. Let me see. Indeed, someone is accidentally sharing a screen. Let me see if we can undo that.
Maybe I can just request control.
Let's turn off the cameras.
Yes, but I cannot see who is. Ah, yeah, it's Valerie. It seems you. No, sorry, it's not you.
C'est écrit en italien. En haut, c'est écrit en italien la
Ouais, ouais.
Okay, now we are back. Yes.
Okay,
Sorry
I'll try
about
again.
that.
No problem.
Yeah.
As always, technology is playing tricks on us, so.
Yes, we see it again.
Okay, let me just go into the. Okay, there you go. So.
Yeah.
We were here, I think. So this is also another important element that distinguishes the RRF from other funds is that it's not only investments, but also reforms. And it has to be a balanced a package of reforms and investments to address the challenges that have been identified for the particular member state with semester context. So there's a very close link with the European semester. And another important element that distinguishes the RRF from other funds is that we have expenditure targets. We have the so-called green expenditure target, which says that all the expenditure that is foreseen by the member state under the RRF have to comprise 37%. And we also have a digital target that says that those measures that are proposed by the member states have to reach the 20% of the member states' expenditure under the RRF. So these are important elements to bear in mind, as we will talk about it a bit later. There are also certain areas that have been identified by the Commission as the common challenges faced by all member states. So not only those identified in the European semester for particular member states, but there are the areas that we should all work together to address. And they are 7. But maybe the one that is most relevant for the justice systems is the one that's called Modernize, which calls for the digitalization of public administrations. That would also include the justice systems. And another one, which is Reskill and Upskill, which calls for education and training to support digital skills. So that's not only for the citizens, but also for the professionals. But obviously, we would need to have both if we want to move towards more digitalization. Now, very quickly, in the regulation, what it says is that the facility has 6 policy pillars. As I mentioned before already, so obviously there's a green transition pillar, there's a digital transformation, the resilience and health, sustainable and smart growth. All these 6 pillars mean that when the member states come up with a set of measures under the RRF, they have to make sure that there are measures under each of these 6 pillars. So they have to contain measures that address each of them. Now, to maybe tell you how does this facility work and how we're going to put this all in practice. So as I mentioned, there is a regulation that establishes objectives of the facility, the financial allocations for each member state, but also the process of how the money will be distributed. Now, as I said, important thing to bear in mind is that the RRF has a relatively short time span. Obviously, it is meant to deal with the effects of the crisis, which requires action now, not later, not in 10 years. So the measures that are included in the National Recovery and Resilience Plans, and these will be the plans which will contain all the measures that the member states want to be financed under the RRF. These measures have to be implemented by 2026. So the last payment that can be made from the Commission to the member state can be only done in August 2026. So it means that the recommendation is that the measures that member states propose have to be relatively mature projects already, so that they are ready to be implemented the moment the plans are approved. So how those plans come into being and how do they become something formal? So within the Commission, we have an established task force. This is where I come from, that is responsible for steering this process together with our colleagues from DG ECFIN. And we are engaging on an informal basis already since August with all the member states to identify what kind of measures they could include into their national plans that would address properly the country-specific recommendations, as well as for them to meet the digital and green targets. Now, when the member states are ready, so they have filled all the elements that have to be there in their plans. They came up with the good mix of measures. They put it down in the Recovery and Resilience Plan. Then, when they're ready to submit it, which the regulation says that those plans should be submitted by 30th of April this year, although it says as a general rule, which means it's not a very strict deadline, but obviously for the member states, the sooner they submit the plans, the sooner they get approved, the sooner they will get the distribution of funds. So once they submit formally those plans, the Commission has 2 months to assess those plans. Then on the basis of that assessment, the Commission prepares an implementing council decision that would go then to the council, and it has to be approved by the council to become a law and to become a formal approved plan. Now, the council can suspend the adoption or payments in case there is a significant non-compliance. And the payments will be done to the member states on the basis of the agreed payment schedule, which will be together with the milestones and targets. So as I mentioned at the beginning, that this is a performance-based instrument. So milestones and targets are those elements that are very important for payments, because the payments from the RRF can only be made once those milestones and targets are attained. So this will be very important when we discuss the payment schedule, because the member states will have to put, okay, by 2022 August, I will attain this particular milestone, and then a certain amount of the RRF will be disbursed to that member state. The member states will have to report on the progress twice a year to the Commission, and the Commission from its side will also have to report to the Parliament and the Council on the implementation of the facility. So just to sum up, the RRF is there to help member states address the challenges identified in the European semester and to advance on green and digital transition. It has to be a coherent package of reforms and public investments. We've seen so far that there has been a lot of investments proposed, but less so of reforms. So this is an important element to bear in mind, that it has to be a balanced approach. So if there is a challenge identified for a particular member state about the justice system, just buying video conferencing equipment might not necessarily address that challenge. It's a performance-based tool, so we will only look at the attainment of the objectives, so the attainment of the milestones and targets. We will not look at how much was spent and then reimburse those costs. This is a different approach than cohesion policy. What is very important is that because it's so short span and so important, that the stakeholders are involved as you in the preparation of the national plans and also in the implementation. This has to be also described in the plans. It's an important element. Another important element is the complementarity. So obviously there are some projects or measures that are being financed from different sources. So it's important to ensure that there is no overlap in funding, and that if there is some complementarity, that we achieve the synergy. So we are not doing for the same project from different funds, and that we attain the best result possible. State aid compliance is an obligation as well. So the funding given by the member states through the RRF would still be subject to the state aid verification. And lastly, but not less important, is the audit and controls. Obviously, we want the money to be used in the right way. So strong controls and strong audit mechanism must be installed by the member states, or the same mechanism could be used, for example, from the cohesion funding as well. Now, coming to the point that's probably more interesting for you as stakeholders of the justice systems, what can RRF do for the justice systems? When we talk about the justice systems, there are two elements of relevance. So, for example, there is a number of member states for which there were country-specific recommendations addressed in 2019 and 2020 linked to justice systems. So for those member states, obviously, having a reform and investments to address those challenges in the justice system will be important, and this is something that we will also look at. There have been, just to give you an example, there are like 16 member states for which challenges linked to the justice systems have been identified. So it's not all 27, but it's a majority of member states. So this will be an important element. Another element that is relevant for the justice systems is the digital transition. So apart from addressing the CSRs, member states also have to reach the digital target. So the 20% of spending, which actually translates into 134 billion of euros. So it's a significant amount of money. So digitalization of public administration, as I mentioned before, is one of the flagship initiatives as well, so one of the 7, and it could translate into the digitalization of judicial procedures. Now, for example, there's also a draft component that we have published in autumn this year to help member states to understand what kind of reforms and what kind of investments they could propose with regard to the digitalization of public administration. So there is a component that is published on the RRF website, and I can share it later on in the chat, that also explains what kind of measures, for example, the member states could envisage in relation to the justice systems. So, for example, member state could envisage investments that would accelerate the digitalization of judicial procedures, focusing on the handling of cases by the judicial institutions, the exchange of information and documents with the parties and lawyers, the continued and easy access to justice for all, the interoperability of different systems developed at national level. These are just some examples of possible measures to be included. Now, this, of course, will depend on the national context, on the challenges identified for that member state, or the member state's priorities identified for the digital transition. Another possible area of measures could be the cross-border initiative, also in the judicial area, where member states cooperate on a voluntary basis to, for example, set up for the e-evidence digital exchange system. But I will not go into too many details, as I know that my colleague from DG Justice after me will talk about this more, and he's definitely a better expert in that. It's just that what I wanted to add on the digital transition is that during the crisis, we noticed that in some member states, the justice systems came to a stall because of the restrictions imposed on the public life. And obviously, we shouldn't repeat this because having effective justice systems is important, not only for us as citizens, but also for the business environment. And it will be an important element in the successful recovery from the crisis. So RRF could serve as a good basis to advance such reforms and to push forward such investments. And just to say that, of course, digital solutions will not only serve to reach the digital target, but it will also support the green transition. So they will go hand in hand. So maybe just to wrap up, the RRF is a sort of a silver lining, as I said at the beginning. It started from dealing with something negative, but it turned into something that will help us to push forward the reforms and investments to make the EU a climate neutral continent and to make it a better continent also when it comes to the justice systems. And I would like to invite you then to share with your ministries and to engage with your ministries what kind of reforms and investments they are envisaging to be included in their national plans. Don't write to me directly, although I'm happy to share my contacts if you ever have any questions, because the way the process has been organized is that to ensure a smooth coordination, each member state has a designated focal point for RRF. In some countries, it's Ministry of Finance. In some, there is a Ministry of European Projects. I don't know about your particular member state, but they are the ones who decide what goes in or not into the national plans. So I would invite you then to liaise with that particular institution in your member state to discuss what kind of justice related reforms should be in there. I thank you very much, and I'm happy to take any questions after.
Yes, many thanks. Well, we are a little bit behind in time, so I then suggest indeed to now immediately go forward with Alexander Ivanchev, who is the head of sector in the e-justice unit within the European Commission, and he will focus his presentation on the digitalization of justice part in relation to the RRF. So please, Alexander, if you are with us. Yes, I see you on the screen. You just have to unmute yourself.
Thank you, Simone, and good afternoon to everyone. Kalispera to Mr. Perakis. I also see some familiar faces. It's indeed a pleasure to be here with you today. Also, many thanks to a very comprehensive, clear presentation on the RRF from colleagues from SG Recover. It is a task force indeed. So if you would just excuse me for 1 second while I try to share my few slides.
Yes.
Can you see them?
We see them very well, yes.
Excellent. All right, so following this very useful and broad presentation on the opportunities under the RRF, I would like to zoom in a bit with regard to issues pertinent to digitalization of justice, or e-justice as we call it. Now, We, of course, renewed our efforts in 2020 in the context of the COVID-19 pandemic for obvious reasons, but digitalization of justice, as perhaps many of you know, is not new. National authorities have been working towards the digitalization of their justice systems for a long time, really, and some member states are very much advanced, others not so much right now. But against the background of the pandemic, it really became essential that we renew the work in this regard with doubled efforts, because the pandemic not only highlighted the need to move to more efficient and effective justice systems, it was really a stress test. Without digital solutions, we would not be having this meeting today. So it's really a matter of resilience. And the crisis has also put into question the very concept of rule of law at some point during the worst of the lockdowns. In fact, there were a number of exercises last year to take stock of the effects on justice systems as a result of the crisis. But I don't want to go further into this because you as practitioners probably know better than myself how it affected your life and your work and the work of the judiciary. So before I go into details, let me just summarize our key deliverables on the side of DigiJustice and the Commission last year. On the 2nd of December, we adopted a very comprehensive package of initiatives with regard to modernization of justice. The first element is the communication on digitalization of justice in the EU, which was adopted together with the staff working document, with the so-called Digitalization Mapping. If you have not had a chance to look at this mapping, I would invite you to. There are links later on in my slides. But essentially what we did during the summer months, also with the very kind collaboration of the CCB and the bar associations and law societies of Europe, is that we did quite detailed work to identify the state of play when it comes to digitalization of justice. We have circulated a questionnaire also to the bars, and I thank you for your contributions in this regard. As a result, we have this document, which is about 70 or 80 pages. I'm not quite sure, but I think we have about 100 questions. We have asked national authorities and stakeholders such as the notaries and the lawyers to gather their input as to how far advanced national justice systems in all EU member states are. Secondly, we also adopted a legislative proposal on the IT system called e-Codex. Some of you I know are familiar with it, but I'm not going to go into detail for the purposes of this presentation. And last but not least, of course, the Commission adopted the European Judicial Training Strategy Forum, and I think I might have the date wrong here. All right, so let me take a bit of a pragmatic approach to e-justice, though, because I think it's important that we establish a bit of a baseline of what e-justice is about. Now, the first element here, I don't think I need to go into details. Obviously, we are very much reliant these days on video conferencing, such as this Teams platform you're using today, not just for this sort of meetings, but also in the context of judicial hearings, for example. When it comes to interviewing witnesses, experts, when there is a need to communicate remotely, also with detention facilities and so on and so forth. Secondly, there is the opportunities offered by use of electronic tools by judicial authorities and practitioners, be that electronic case management systems or any sort of electronic channels for secure data exchange, such as, for example, submitting evidence from the police to the court or a claim from a lawyer to a court and vice versa. Then we have the various digital public services in the area of justice. These are, for example, the various public registers which provide easy access to information, for example, on businesses, on land plots, or more restricted kind of systems which would allow, for example, citizens to obtain an electronic criminal record where that's allowed, because I know the legal situation is also evolving, and this is part of the reform, because access to public documents obviously is a field where citizens and businesses have a high interest in. Being able to have a legally valid birth certificate, this is a possibility in some member states, not in all, unfortunately. Electronic service of documents is also a developing field. On the EU side, just last year we have adopted 2 new regulations, which in fact make the service of documents and taking of evidence in civil and commercial matters mandatory the use of the digital channel. So the regulations have been adopted, but of course this concerns only the cross-border communication. Another example is the online publication of case law with the objective to ensure better transparency, with the objective of ensuring better access to case law, the uniform application of EU law based on national practices. And also with regard to the publication of case law as open data, which is really the fundament to also building solutions based on artificial intelligence, for instance. And talking about artificial intelligence, of course, there is the entire discussion, and because obviously AI has reached the justice field as well. We are also working in this direction. In member states as well, there are already quite a few national good practices when it comes to use of AI solutions for anonymization or pseudo-anonymization of judicial decisions, for example, to make them GDPR compliant. The use text or text-to-speech applications, for example, to generate automatically a transcript of a hearing. Process automation for improving the efficiency of workflow, document management, workflow processing, etc. Of course, there is this whole debate we have now going on in Europe on the use of AI for predictive justice purposes, and there are a number of considerations there, but again, I'm not going to go into that right now. Now, coming back to our communication, well, this is this document, first of all, sets out our strategic vision for what the future of digital justice should look like, and more importantly, where the priorities should lie, both from the perspective of EU action and at the national level. And the communication itself is built around 3 main pillars. One of them being that it takes stock of the various financial mechanisms which we hope member states will benefit from to move forward with modernization and reform. Now, here I would like to take a bit more detailed look at the digitalization mapping. As I've already mentioned, it is quite a comprehensive overview of the state of play when it comes to digitalization of national justice systems. And we did consult a very large constituency in this regard. Here you have a link to the mapping if you're interested to see where your country stands in this regard. And we will take this forward. This was not a one-time exercise. In fact, as you may know, digitalization of justice has been monitored through our EU Justice Scoreboard, but the elements which have been included so far were limited. And in fact, as of this year's edition of the Justice Scoreboard and going forward, we will be taking a very detailed look to track and monitor how digitalization of national justice systems progresses. Now, let me give you a few examples based on this mapping. This is based on the replies we have received from the bar associations, the 16 bar associations and law societies of Europe. So here, for example, we compare the use of video conferencing and whether video conferencing facilities exist which allow lawyers to fully carry out their work. So according to the answers, and again, I need to open a bracket here because all these answers are very much high level, so I'm sure a lot of caveats exist. But in 5 member states, this is apparently possible. In 2 member states, lawyers are able to use video conferencing in most aspects of their work, and in 9 member states, they're limited in this regard. This doesn't really give you the answer why, but it still allows for a good high-level tracking of the state of play. Then another two questions I have included here, and this is, by the way, certainly not how you do a PowerPoint slide with this law of text, but the two other examples I'd like to give here is relate to digital access to court proceedings in criminal cases. And in 7 member states, as you can see, there is the possibility to have secure communication between defendants and defense lawyers to guarantee the confidentiality during hearings. In 6 member states, this possibility partially exists, and in 40, it's not currently possible. And then another example here is with regard to being able to initiate a case through digital channels or file an application, as well as to ensure further follow-up. And you have the data as well. I'm not going to go through this and read it. As I said, there are also a number of other aspects which the mapping explores, so you can take a closer look at it if you so wish. But here I get actually to the gist of it. How does this really link up to the RRF? Well, as explained in a very good level of detail by colleagues from SG Recover, the RRF is the key financial support instrument in the aftermath of the crisis. Well, it's still ongoing, which can support national digitalization reforms through both reform and investment action. In fact, I did just prior to this meeting, I compared the overall budget of the RRF with the Marshall Plan. And it's interesting to note that, in fact, the total budget of the RRF is more than 6 times the expenditure budget of the Marshall Plan for Europe in 2019 prices. So it is indeed a unique opportunity to rebound from the EU effects of the crisis and move forward with these much needed reforms, also with regard to justice systems. As highlighted by colleagues in SG Recover, there is time is of the essence because all national governments need to submit officially their finalized plans by 30 of April this year. This is a legal obligation set out by the RRF regulation. This is where I am coming forward with my plea to you, because obviously legal professionals such as lawyers are an integral part of justice systems. If you have not been involved in this process, because I also know that in some member states there have been public consultations on the draft plans, but if you have not been involved in this process and are very much interested to see what your national government has in mind to propose, or have ideas which you think should be proposed for funding in the context of the RRF, please do take contact with your respective national authorities. Now, indeed, there is a focal point in each country, but I would say that in our specific case, your first port of call should be typically the Ministry of Justice, not ministers as I have here. And see with them what kind of measures are being proposed and what can be included, and also, of course, to take into account the needs of lawyers, because, for example, in some of the draft plans we have seen, and I cannot really talk about them, but some of them are quite ambitious. When we have integrated systems for electronic communication between actors, it should not be just courts and prosecution offices and the police, because lawyers are, of course, an integral part of this process. So I would very much like to invite you to take contact and see what's being drafted at the moment, because, as I said, again, time is of the essence. Colleagues have also highlighted the possibility to finance multi-country or cross-border initiatives. This is indeed the case also in our case. If you have ideas, you'd like to join forces and, let's say, work towards interoperable video conferencing systems for communication between different countries, that's just one example I can give you today. And with this, I will conclude my presentation. You have a few links here which are included for your reference, and I thank you very much for your attention.
Many thanks, Alexander, and both of you for your excellent presentations. Indeed, you have explained very well that this mechanism basically is channeled through the national, through the countries, and so money is being made available. But the countries, as far as I understand you correctly, they have to set the priorities from their side. And then funding will be channeled through the national administrations to the local actors, as far as I understand. So this is not a program that operates through calls at European level, but it operates through that. And therefore the call, indeed, as far as I understand you, to all our national bars to basically bring to the attention of their administrations regarding the needs as far as lawyers are concerned, concerning, for example, a digitalization aspect, but other improvements that can be made in the field of justice. Yes, I think I've understood you correctly. So then I would like to open the floor for a couple of questions. Again, we do have a lot of participants. We also are lagging a little bit behind in time. So, but nevertheless, I just want to give an opportunity for a few questions. So those who would like to take the floor, please raise your hand, and then we can, you can take the floor. If I see, yes, I see Carlo Forte. Please, Carlo.
Thank you very much, Simone, and thank you very much, dear colleagues from the European Commission. My question is, after the 30th of April, if, for example, a country will present a plan which is not fully satisfactory in order to develop the digitalization of justice, how large is the space for negotiation, and if we can still consider to contact the Commission in this regard? Thank you very much.
Shall we?
Yeah, please.
Shall we answer? Okay,
yeah,
so maybe I can answer this question. First of all, what is very important is the informal exchanges with the member states that are happening now already. So the biggest amount of work actually will be put into making sure that the plans, once they are formally submitted, are of good quality. And what I mean by good quality is that it's not really a subjective evaluation. It is actually quite clearly spelled out in the regulation what elements have to be in a plan and how the Commission has to assess those elements. So there is a grading system actually for each element. There are 11 elements that have to be assessed, and each of those 11 elements get a grade. And then there is also rules established what kind of grading is a pass and what kind of grading is a fail. So if we talk about the justice systems and the ambition, obviously, I think there it would take us back to if that particular member state had a CSR on justice systems and whether what they had proposed in the draft plan is enough to address that challenge. So obviously, before that plan is submitted, we will work with that member state to make sure that what they propose is ambitious enough. Because once the plan is submitted, the clock starts ticking and we have 2 months to have it approved. Now, there is always a possibility to stop the clock and to go back to the member state if we see significant deficiencies, and that would lead to a rejection of the plan. Then in agreement with the member states, we would stop the clock and we would continue talking on how to address. But the key element is that the regulation says that the CSRs or the biggest majority of CSRs has to be addressed in the plans. So once again, that takes us there. And of course, another element that could also play in this regard is the digital target. So if we see also that the member state is not reaching the digital target of 20%, that would also, we would discuss that with the member state before the final submission to make sure that they have enough of digital measures in their plans. So all of this would have to be done already now, and that is once again another plea for the time is of the essence, and the moment is now, not later.
Okay, thank you. I don't know if Alexander wanted to say anything.
No, nothing further to add. Actually, myself, I'm a bit ignorant on this. I was interested myself in the answer to this question, Simone. Thank you.
Okay. Well, I haven't seen any other hands being raised, so I will then just suggest to move on, given the timing. So many thanks to both of you for your clear presentations, which will also be made available after our meeting. We will circulate them for those who have access to our extranet. Some of our presentations are already there, but yeah, we will also circulate them. So the second part is on the funding opportunities under the Justice and the Citizenship, Equality, Rights and Values programs. So the first presenter from the European Commission is Ms. Karavasili, also from the DG Just. Please, if you can, yes, see you. Yes, thank you.
Can you see me?
Yes, we hear you as well.
So, hello, good afternoon, everyone. Thank you very much for this invitation. I'm very happy because it is very timely. Actually, we're finalizing the work on the preparation of the next work program for our two programs, so the Justice Program and the Citizens, Equality, Rights and Values Program. We are ready to launch, to open actually our calls for proposals this week. So I really hope that you will find some useful information in my presentation, but also in the discussion that will ensure we can cover also maybe other points. So let me open my presentation. Can you see it?
Yes, it's on the screen. Thank you.
Okay. As I said, we are right now in the final steps of adopting the program's next basic act, the next regulation, which will cover the next 7 years, 21 to 27. And in parallel, we are finalizing the work program for the first 2 years. This is actually the first time that we work with a biennial program. Usually we have annual programs. And in parallel, we are also doing some preparatory steps, which is the preparation and the launch of the calls for proposals under the work program, all in an effort to minimize the delays that have in any case been incurred due to the late agreement on the MFF and the late adoption of the regulation. So we really hope to be able to catch up on some of those delays. So for the ones that are already familiar with the previous justice program, they will not be surprised because actually there is continuity in the objectives of the new program. The new justice program will continue to contribute to the further development of a European area of justice. It will continue having the 3 specific objectives out of the 4 it had. So we don't have any more the drug prevention specific objective that will be part of the Internal Security Fund. But we will continue support via the program Judicial Cooperation in Civil and Criminal Matters. We will continue promoting judicial training. And we will also have the support for projects in the area of access to justice and e-justice. From the point of view of budget, I'm afraid the news are not very good, and also it is intimidating every time I speak about budget in the context of presentations where we heard before about billions in the RRF, but here we come down to the context of millions. So for the whole 7-year period, it will just be 305 million. That amounts to about 45 million per year for all the activities supported by the program. And what is new is that the new regulation will impose on us earmarking on how we spend this budget among the specific objectives supported by the program. You see there the percentages, which are not very far actually from the current allocations in the previous 7-year period. And we also have a 10% flexibility to invest in actions in relation to the rule of law, to which the new regulation puts particular emphasis. The types of activities to be funded actually are not significantly modified. So you see there the first 6: awareness raising, training for stakeholders, mutual learning through the exchange of good practices, analytical and monitoring activities, support for the development of IC tools, and support for key European networks. We had that already in the previous program. What is new now is that the program can support activities for the capacity building of civil society organizations, and there will be also some funding to support activities on awareness raising of the program's results. On monitoring and evaluation, the news is that we will need to have a disaggregation of data, of results produced by the projects, disaggregated by sex, and also the evaluation of the program will need to include a gender equality perspective. This comes with the new regulation. The new regulation also is very good in that it provides, as part of its articles, a definition of what is judiciary and judicial staff. This is very useful because this is actually the biggest target group of activities funded by the program. So judiciary and judicial staff does not mean only judges, prosecutors, and members of staff of courts and of prosecutors' offices, but it also includes other justice professionals associated with the judiciary. And this could be lawyers, this could be notaries, bailiffs, or enforcement officers, insolvency practitioners, mediators, court interpreters, translators, court experts, and prison staff and probation officers as well. So this is a quite big target group. Although it is true that the program's bulk of support, let's say, is for judiciary and judicial staff, but mainly judges, prosecutors, and so on. For the main features of the new program, there is continuity from the previous work program for the ones of you that are familiar. So we would like to maintain the co-financing in all our action grants calls to 90%, and we would like to maintain the co-financing of 80% for the operating grants. We will continue supporting both national and transnational projects depending on the call. And the minimum grant amount, we will keep it to 75,000. Given the budget that was not significantly increased, we can unfortunately not be very ambitious, not be very bold with developing new priorities or increasing the funding of existing ones, or we are not able, for instance, to support big budget projects. So we will need, by definition, to stay at similar annual budget levels as in the past. This ensures continuity, but unfortunately, we cannot really evolve the program into new priorities. The main features in the new program, as I said, we don't have the drugs prevention specific objective anymore. The program will be biennial, and we have the ER markings. And we will have as well the new cycle of support for 4-year partnership agreements with selected networks that will be selected through an open procedure, of course. Now, in what has to do with the calls for proposals, so we will maintain the call in the area of judicial cooperation in civil and criminal matters. So these are transnational projects, but we will also offer support here for national projects in one area to support the development of national networks, both in the area of civil and in criminal matters, but also the support of member states for the connection of their national ECRIS systems to the central ECRIS system. We will continue having the call on judicial training at the same level, more or less, as in the past. It seems that we have less funding now in this call, but actually it's because the support for training of judges in the area of competition law is not anymore with our program, but is with another program. And we will have also, as in the past, the two calls in the area of access to justice, the call supporting e-justice projects. So the priorities that Alexander spoke about earlier, but this is not to support, of course, big projects supporting the national digitalization. This is more for cross-border cooperation projects in the area of e-justice. And we will have the call to support transnational projects aiming to enhance the rights of persons suspected or accused of crime, and also the rights of victims of crime. This call, actually, I have noted there the deadlines. This call will be launched later than the other ones. In the area of operating grants, the new regulation includes an article as the previous one as well, which tells us that we need to support the work of the European Judicial Training Network. We need to support its program. And in this effect, we will award annually an operating grant, which amounts actually to about 25% of the whole program's budget. And this is significant funding in the area of judicial training. At the same time, we will launch in 21 a new cycle of framework partnership agreements where we will support European level networks, and these are formal networks having members in at least 14 member states. This will be an open procedure, and the objective will be again to support the program of these networks via operating grants in the years 22 to 25, again through an annual application where we will assess the plans of these networks for their annual program. I note there the indicative budget for the operating grants, and this includes as well about 11 million for the European Judicial Training Network grant. Just for info, these are the framework partners of the last 4 years. These are the ones in the area of judicial cooperation. And these partners are the ones in the area of access to justice. So we have supported their work program for the past 4 years. And what are now the next steps in relation to the program? So our plan is by mid-March to open the calls for submission of proposals. The calls have been published already in the Funding and Tenders portal on 3 March. In case you want to know more about the calls, you need to visit the portal. I have put the link there, and I will put it also in the chat after the presentation. In case of questions, I put there our contact details where you can reach out to us on any question either about the program or about the calls. The next step is that towards the end of March, the biennial work program will be adopted, and towards the end of April, we expect to have the adoption of the new Justice Program Basic Act. So things happen this year a little bit in reverse. Normally, we already have a Basic Act, and we adopt first the work program, and then we publish the calls. But all of this now is done this way to avoid further delays and to actually be able to disperse funding to applicants as fast as possible. As you noticed in my presentation, the deadlines are really very close. They are in the beginning of May. So we really need to reach out to all the program stakeholders and make this information known on the calls. So I invite you to visit the portal. I just have a couple of slides to show you what you can find there, but of course there is a lot more to discover. So this is from the page where our 5 calls are published, the ones I spoke about earlier. And this is the page from one of the calls, the Judicial Training 1. So if you go there, you can find, for instance, a lot of the information on the call. What are the objectives? What are the priorities? What are the conditions for applying? Useful documents about the call. Partner search as well. There is a facility in the portal where you can see, for instance, others who are active and would like to partner for submitting applications. And also there you can find the link to actually start the submission of your application. This is a page actually from the call, a previous year's call on judicial training. Actually, in the Funding and Tenders portal, you have the opportunity to visit the pages of all the past calls we have launched in the program, under the program. And in those pages of each call, you can actually find information on which projects have actually been awarded. So this is very useful information in you as an applicant, a potential applicant preparing your proposal, to know already what other projects we have funded in the same area. I invite you to really visit those pages, and actually in a few weeks, months, very shortly in any way, this is going to be improved. So instead of just having an abstract of the project, you can actually find out more information such as deliverables and so on. So in any case, all the public information about previously awarded projects. So thank you for your attention. I believe my colleague Francesco now will follow to present you information on the Citizens' Equality, Rights and Values program, and then maybe we can have a Q&A session.
Yes, many thanks. So indeed, that was a very comprehensive presentation as well. So if Francesco could also take the floor, I understood, yeah, indeed, apart from the SURF program, he will also explain some of the do's and don'ts of the application process, which is of course also very useful. So you could turn off your sharing screen, Maria, if that is possible to turn off the, yes, thank you. And then if Francesco could take the floor.
Thank you, Simone, and thank you, Maria. I'll start with my presentation. So I hope that you can see the screen.
Yes, very well.
Voila. Okay. So thank you for the floor. Thank you for these opportunities. I'm here to present the Citizens' Equality, Rights and Values program. Just like my colleague Maria, she briefly presented now, we have a work program coming up. Unfortunately, the work program of the SURF program is not out yet. You will need to be patient for at least 2 or 3 weeks more, which is why probably my presentation will not be so much in depth, just like my colleague Maria had, precisely for this reason. So in 2 or 3 weeks, you will have the work program and the different calls for proposals and the details on the funding opportunities and budget and policy priorities. Now I can only share with you what are the objectives, the strands, the aim of the program as a whole, more as an overview. And let's see if you will be interested. I hope you will be interested, although I understand probably the Justice program is actually the right funding program for you. But I hope that you find also this one. So what are the objectives of this SERVE program? For those, again, who are new, the SERVE program is actually a merge between two former funding programs for the Commission. Previously, there was direct Rights, Equality and Citizenship program and the Europe for Citizens and the Europe for Citizens program, which now became one. And there is everything that was in the previous program has been integrated into this new program, and you will find the same specific objectives in the different strands that I'll present you now. So the overall objective of the SERVE program is to protect and promote the rights and the values that are listed in the treaties and the Charter of Fundamental Rights for an open, right-based, democratic, and equal and inclusive societies. There are four strands. So for, let's say, for objectives or strands, as we call it, which are the union values, equality and rights, citizens engagement, and Daphne. So the equality, rights, and gender equality strand and the Daphne strand was previously the REC program, the Rights, Equality and Citizenship program. And the citizens engagement and participation strand is what was before the Europe for Citizens program. The union value strand, it's something that is new. It has been actually integrated in the program following requests from the European Parliament. So during negotiations, the co-legislators, the Council and the Parliament were negotiating and discussing on the program, and in the end, the agreement was to include this new union value strand, which means funding opportunities for what? These EU values is probably relevant for you. They are actually, you can find them in Article 2 of the Treaty of the EU. And we are talking about human dignity, freedom, democracy, equality, the rule of law, very important, and human rights. These are listed in the Article 2 of the treaty, and this is where actually we refer to for the union values. The legal basis of the SERVE program, it's quite long. We have 6 different articles because the SERVE program, and I'll show you briefly in details. We cover several areas. From data protection, non-discrimination, citizens engagement, culture, and health. I'll show you how these are the 4 strands, as I previously talked to you before. The EU values is the first one, to protect, promote, and raise awareness on the rights by providing financial support to civil society organizations. The budget available for this specific objective, for this strand, is around 700 million of the overall SERVE program. Something I didn't mention before, the overall SERVE budget is of 1.5 billion euros. So it's substantially more than, let's say, comparing to the Justice program. And again, our proposal, the Commission proposal, was for 640 million, which was substantially increased following the negotiation and thanks to the European Parliament, which included this EU value strand and which which equipped this EU value strand with 700 million euro available for funding projects under this strand. It is mostly actually first and foremost for civil society organizations, for the capacity building of CSOs. Then the second strand, it's on the equality, rights and gender equality. We have several areas, several policy areas covered here. We're talking about non-discrimination, the rights of the child, the rights of persons with disability, EU citizenship rights, the freedom of movement within the EU and to reside freely in every member state, and the protection of personal data, so the GDPR. So we had in the past several calls for proposal to promote and protect the equality and gender equality, and also to fight non-discrimination and to fight racism, discrimination and fight racism. And clearly these funding opportunities will continue also under SERVE. The overall budget available is of 460 million for this strand, and for the other strand, which is coming up, is the Daphne strand. So it's actually a combined budget for the two. Now we'll go to the citizens engagement and participation strand. Here the budget is of around 400 million for the 7 years. And what do we cover? We do cover here projects on town twinning and network of towns. So for the municipalities and for local authorities to partners across member states. We do also cover project for citizens engagement and participation, the involvement of citizens in the democratic life of the EU, and also the European remembrance. So it is about remembrance. Usually it's true that we do focus on the remembrance of terrible aspects that happened in the past in Europe. Of course, we're talking about the totalitarian regimes and the Holocaust and so on. So we do fund projects which remember this aspect and the lessons learned, and what can actually what can we draw from the past in order to continue with the European integration. The last strand is the Daphne strand. This is about fighting gender-based violence and fighting domestic violence, violence against children and young people, and also violence against other groups at risk, such as LGBTIQI person and persons with disabilities. Again, the budget of this strand combined with the budget of the strand of equality is for 460 million euros. Here is actually the overall for 1.5 billion, the overall budget of the program. As I said before, we propose a budget, the Commission proposed a budget of 640, which was in line with the previous programs. And then we receive a top-up following the negotiations and the agreement reached by the Parliament and the Council. What are the type of activities that we fund? Similarly to the Justice program, we fund awareness raising, training for stakeholders, training for public authorities, for civil organizations, studies and procurement activities that support the policy development of the Commission and the proposal of new EU legislation. We also support operating grants. So it means the running cost of EU level networks and EU think tanks, which implement the objectives of the program. So the different strands, and then most importantly, as I've mentioned, we under especially the Union Values strand, the Union Values strand, we will cover funding opportunities and capacity building for civil society organizations. And we will also cover the program contact points. This is a novelty for the program as a whole, but it's something that we inherited from the Europe for Citizens program, where there were each member state had nominated our contact points in order to promote the program and to support also potential beneficiaries in the application process. This is something that it will continue, and of course it will cover the whole program. So there will be program contact points in each member state, which of course will be a reference point for potential beneficiaries, including you. The new features that we had with respect to the past, it's once again the support to CSOs and the increased focus on the rule of law, especially through this Union Values trend and the program contact points that I've just mentioned before. Very briefly on what are probably the common mistakes and what you should include in your proposals of SERP, but I think I can also speak for the Justice program. Usually what we see is that there is not enough or a poor needs assessment on why you want this project and this activity to be funded. So please give us a reason on what are the conditions on the ground and why you would need this funding. I'll give an example. If there are certain conditions in certain member states, or even in regions, member states of discrimination or on certain minorities, or if there is if there are cases of racism and so on. So please let us know what is going on the ground, and this is basically the needs assessment. Please also identify the target group. Usually here what we see is that we have a target groups as women, but okay, this is an example, but women, it's a lot, it's half of the member states population, even more. So please try to identify better about the age group, about if they come from certain minorities, and so on and so forth. On the selection of member states, of course, also why you would need support for again a municipality or a region or a member state or different member states together. Bear in mind that this program, in this program, you can submit proposal for transnational projects, but also for national projects. So simply let us know why the member states or the local regions. Another point is of course, these programs are ongoing since several years. It is a new program, but it has of course coming from the past, from previous programs. So there are already activities ongoing, let's say, on the rights of the child. So also let us know what are basically let's say the novelties and the avoid of duplication of what has been funded so far. Risk and mitigation measures also. Please let us know whether there are any risks. For instance, it's about the protection of data. Clearly, if your project is collecting sensible data on certain minorities and also on the hatred online, for instance. Something else? Yes, please. Also on the implementation of activities and the results. We do look for the results and not only the, let's say, the deployment of the activities. So what actually your project aims at. So of course you would have certain trainings, let's say, for the local police in order to sensibilize them with vulnerable groups that may face some problems. But so the activities, you may have some trainings, but what is the ultimate aim and the results? Of course, you'd like that overall there is probably less bias and less racism against certain people. Let us know not only what you want, what are your output, what you want to do, but also your outcomes, what you want to achieve. On the budget of Part A and Part B, there are two forms that you will need to fill in. This is just probably a technicalities for you. Try to see that the budget in the two forms overall matches. What makes a good project also? We have, of course, in the past, we've had always some criteria. Our criteria that is specified in the work program and in the call for proposals. Among them, it's certainly the relevance. So we do have certain priorities, and Maria in her presentation clearly outlined the priorities of the call proposal of the justice program. Of course, also for SERV and for the different strands and the call for proposal, there will be certain policy priorities linked to let's say, also to the strategies and the action plan that Justice has adopted this year. I'm talking, for example, about the Rule of Law report, but also the European Democracy Action Plan and the Gender Equality Strategy and the EU Framework for Inclusion and Equality and the Anti-Racism Action Plan. So all this, of course, will be supported by the funding and by the projects. So have a look at the priorities and please make sure that your project proposal is in line with these priorities. Again, try to address a need that comes from the ground in the field. And specify the objectives that should be achievable. And we do also understand that these projects probably, although we wish they will not change the universe. So we do understand that there is limited funding available. So try also to have something that is achievable and voila. So for strong partnership, again, can be either transnational or national, and let us know what are the strengths of each project partners and the different activities that they will carry out in the implementation of the project. The EU dimension and the EU values, whether it is transnational or EU or national project, it shall have an EU added value. For national project here, I'm talking mostly, for example, we do have, and especially in the Justice program, we do have a lot of directives, a lot of policies that the EU is presenting. And we also do look in the EU added value how these directive or how these policies or action plans of the Commission are implemented in the field. I understand this can be probably how to best describe the EU added value for a local and regional project. We have the Anti-Racism Action Plan, we have the Council Framework Decision to Combat Racism. So we do have some policies and some directives. So please try to see how this can be implemented also at the local level if you are looking for national projects, for instance. About the results, I've already mentioned this. This is important to specify them and to have them again realistic, especially for the activities and the result that you want to achieve. We do also look for cost effectiveness, so on the ratio between let's say personal cost and activities, and we do this is also for what concerns the personal costs and activities, and the subgranting aspects that should be limited to a certain amounts, if you wish to do so. The subcontracting, sorry, to a certain amount. What else? Usually we have 2 years project. This is what we actually have had in the past, and it will continue like this, probably with some exceptions for serve. I think that I'd like to stop here. I went probably rather quick, but I'm open for questions, me and Maria, so I can stop this monologue and voila, I leave the floor to you.
Many thanks. It was an interesting monologue and very rich with a lot of information. I see this program indeed offers really a very broad range of opportunities on different fundamental rights, citizens' rights, etc. So I would give the floor indeed to the audience to give the opportunity again to raise questions. If there are any, yes, I see a question from the chair of our training committee, Nicolas Koutkias. Please, Nicolas.
Good evening, everybody. Ms. Karavasili, Mr. Borzonello, thank you very much for the interesting presentation. I have a question about the judicial training. The call for proposals for action is addressed only to the Ministry of Justice, is addressed only to the national authority, or the bars and the professional organizations have the right and the opportunity to submit a proposal and can take a fund for an e-justice project?
I
think this is for Maria or?
Maria, yes. Simone, it's for Maria.
Yeah.
So, so both for the, I did not understand if it is for the judicial training call or if it is for the e-justice call, but certainly in both calls, it's not just for the ministries of justice. Actually, in our program, ministries of justice, they are more involved, I would say, in the judicial cooperation call. Our applicants come from a wide range, even academia, not only the ministries. So both calls are open to all types of applicants, actually.
Okay, thank you. We have also another person, Mariana Piontek from the Polish bar, who would like to ask a question. Please, Maria.
Good afternoon. My name is Mariana Piontek from the National Bar of Attorneys at Law in Poland. I want to ask whether projects aimed at women lawyers' professional activation and development could be financed under one of the presented programs, and actually which program would be perhaps better and could we apply as a bar? Thank you.
I think, Francesco, maybe you can find something under the SERV priority.
Yes, we do have certainly because I'm already thinking about the policy priorities. I think it depends how you probably formulate the proposal, whether it is about strengthening and promoting gender equality, if I understand well. It is about probably women's position in bars and associations, or yeah, we would need probably to see, or if it's about something else, I don't know, about trainings or.
I think this would involve different elements. However, now it is just a general idea. But perhaps I could contact you by email.
I think the answer is yes. The answer that we want to give is yes. You can apply for sure for either of the two programs. I think it depends also on the proposals. But I would advise you once also the SERV program, work program and call proposals are out, to have a look and see, and then eventually you can contact. Maria gave the contact of the functional mailbox where there are actually people behind, and you can write, and then we will reply to you. We will reply to you. We will have a look. We cannot give, of course, let's say, prejudgment on the proposal itself, but we can guide you certainly where it would be justice or unserved. This we can.
Perfect. Thank you very much for all the information. Thank you.
All right. I don't think there are any further. Yes. Please. There is an echo here.
Yes. Hi. This is Pierpaolo Vinci speaking from Italy. Just really a fast question, that is, as far as I understand from the previous question, these funding opportunities are also open to legal professionals, that is single lawyers or law firms as well, even not necessarily through the bar association or institutions. So the idea is, since I've seen that there is room for digitalization of the justice work, which might encompass also digitalization of the legal profession, the question is if these funding opportunities might be open also to, say, digitalization of the legal profession. That is, I want to build up a legal tech company that combines legal digital solutions and the legal profession, if I can apply for these funding opportunities. Thank you.
I will have to be negative. At least the justice program is not the program to support this type of activities.
Thank you.
Yeah, for the digitalization, what we have under SERV is actually about online hatred and also online violence against women. This is mostly what we support. Yeah, this is actually, yeah, this is what we try to support. Voila.
But is there a way, it seems I'm new to this network, also in any case, to find all the materials which have been displayed by the senior person who have intervened today? Where can I find all the materials? On an internet site, on a link or something?
Yeah, well, we have a restricted website for our membership where some material is available, but we will, in any case, for all people, including you who have participated in this meeting, by email circulate the presentations of today. So you will get through that afterward. Okay. Many thanks. So then we will, yes, I thank also both Maria and Francesco for their presentations. And we will then continue. Well, we had originally scheduled a coffee break, but if there are no objections, we will just continue the program. And so we are then again perfectly on time with our schedule, because we still have further sessions to go. So anyone in need of coffee or tea or anything else can just serve him or herself, and then we will continue. So with the program. So the next presentation foreseen is on the grant management process. And there will be some explanation on that by Mr. Boving, so who is the head of the grant management sector in DG Justice. So I would like to give him the floor, Philippe.
Yes, thank you.
Yes.
Do you see me? Do you hear me here? Okay,
perfectly.
Fine. I will try first to upload my presentation. Oh, does it work?
Yes, it works. We see it.
You see it?
Yes.
Ah, that's great. You see it, but I don't see it.
Ah, okay.
This is a miracle of technology. Okay, but you see it then.
Yeah, we are on the first page. It's not in full screen mode, but that doesn't matter. It's visible.
If you want, I can change, but okay, I'm not a specialist, but if I change, do you see?
Yes, it goes.
Okay,
Yeah. We are on the second page.
Okay,
yeah.
That's great, because then I have you in front of me on my screen, which I have the impression to talk to someone at least, which is good. So I guess this is the most technical part of the day. At this time of the day, I guess it will be quite tough. But okay, we will try to go through it. So I will give you a few words of explanation about the grant management process. I don't know if you are all familiar with the process. Some of you are, some of you maybe are not. But so I will try to make really a general presentation with a few do's and don'ts as well. So here you have a picture of the process. In fact, the process should begin already a little more at the left, should be extended a little more at the left side, where you have the publication of the call, the closure of the call, the submission of the proposal, the evaluation of the proposal, and then you have the process of the grant agreement. Okay, so you see there where we start. After the evaluation of the proposal, you have the grant agreement, preparation, the signature, then you have the project duration, the final report, and the closing of the project. That's more or less the process. So the explanation I will give you is indeed about the grant management process, but all this is also to take into account when you submit a proposal, of course. So it's when we will discuss the budget is something that you do at proposal stage, of course. Okay, so when we are now at the grant preparation stage. So if I take the process, we went through the evaluation, proposal have been positively evaluated, and the successful applicants receive an invitation letter. So that means that they are invited to enter into the contractual process of contractualization of the agreement, the grant agreement. And so you receive this with an evaluation summary report, which is the summary of the evaluation done by the experts. Okay, so you are invited to enter into this grant agreement process, preparation process. In DG Just, what we do to help you in this process is immediately after you receive this invitation letter, we send you immediately through the portal, because all the communication happens through the funding and tender portal. Everything is automatic, everything is digital. We send you a communication with the main instruction. So we will take you by the hand into the entire process. Okay? That's the idea. So what is the grant agreement preparation? In fact, the grant agreement preparation is not really a negotiation. We will not renegotiate your proposal. Your proposal is, voila, as you have got the explanation today. The call for proposal are published now on the funding and tender portal. You see all the conditions and you draft your proposal, part A and part B. You submit this proposal, they are evaluated by the experts, and then we put them in this grant agreement. The idea is, in fact, also for reason of equal treatment, that we do not renegotiate a proposal. If indeed you go through the process of evaluation and then you change completely the consortium, of course, it is not the same proposal as the one that has been evaluated that would be granted. So the idea is, it is not a full renegotiation. It is, we take the proposal as it is submitted, but we will fine tune, okay? And there are some changes. So what do we change, in fact, in this process? First, we set the date. We set the date, the starting date. Normally, it is the first day of the month after the entry into force of the agreement, or it is a fixed start date. But be careful, because we do not like too much the retroactive starting date. Then also, and we notice that also, I don't know, for the ones who are familiar, we do not like retroactive starting date, and we do not like too much either the starting date too long to find the future. Sometimes beneficiaries apply to a grant for a starting date in 1 year, for instance. But there is a kind of disconnection then with the call for proposal. So we would like the action to start within the 6 months of the signature of the grant. That's the idea, with exception, of course. Duration, okay, in principle 24 months. We set also the EU contribution and the pre-financing. So EU contribution for justice up to 90%, with a pre-financing of 65%. So the idea of the grants is that we give you the money to complete the action. So we give you almost everything you need to do the project up to the end. Then in the grant preparation agreement, in this phase, an important part of it is the validation of the entities, the full validation of the entities. This is not done by us. This is done by the Research Executive Agency. But everything is automated as well. You receive automatic email, etc. So it's really an easy process. It is an easy process as long as you answer quickly, of course. If you take too much time for answering, then it delays the entire process. We check again the eligibility, the exclusion, and we check the financial capacity of the applicants. Not for the public organization, but for the private entities. We always check the financial capacity. We want to make sure, but it's kind of a formal check. But anyway, it's a kind of security that we built in to make sure that the beneficiaries are capable to bring the project to a good end. So we run a few ratios. Now, if the financial capacity is not good, then we can take measures. Indeed, we do not pay the pre-financing in full. We split the pre-financing. We may replace the coordinator of the project as well. So we may take some measure. In this phase also, we implement the evaluation summary report comments. So that means if there are comments from the evaluators on the cost efficiency, if they say the budget must be revised or whatever, we do it at this time. We check also the plagiarism. If there are double funding, etc. We have some built-in tools to check that, data analysis, etc. So we run the check we can at this stage. We check the budget. We check the clerical errors and the inconsistencies, and we draw your attention on the EU visibility rules. Okay, so this is a kind of important phase in the life of the project. Now I will give you a few elements about the budget of the action. And the budget of the action, I mention it here, but of course, this is an important part of your proposal. When you make your proposal, so you make your proposal, the objective of your proposal, etc. You will also have some deliverables in your proposal, work package, etc., work streams, and you of course have to evaluate what kind of input you need to achieve your output, and that's your budget. Now we used to have, I don't know, for those of you who were familiar to the programs in the past, we used to have a detailed budget, an Excel detailed budget table, and it was awfully detailed. So you had to mention all the names of each staff member working on the project with the planned number of hours, etc., etc. So and the fact is that a lot of applicants complained because for a lot of them, it was a double entry because they already have an internal tool, a bookkeeping tool, or cost accounting tool that allow them to make this kind of budgeting. While if they had to fill in an Excel table afterwards, it was a double work. So we dropped it for simplification reason and for lightening the burden on your shoulder. But now we recommend you, of course, to have a detailed budget of what you plan to do. If you want to have an idea of a budget, you need to know how many hours of people of this category are working on the project, etc. How many travel you foresee, etc. So this is really important. So we recommend you to still have something like that. Now, the kind of project we have, the kind of budget is a mixed between actual and unit cost. For those of you who were working also in the past, normally we always add only actual cost. Now in the new framework program, we also introduce the unit cost. So we have the actual cost still is the rule, but we also have the unit cost for travel and subsistence, for SME owners, and for volunteers. I will come back to this. A big simplification as well, compared to what we used to have before, is that the budget transfer are free. Before there were budget transfer between categories of cost, between participants, etc. They are free, as long as it does not, they do not imply a substantial change in the description of work. Before there were limitations, and limitation may lead to rejection of cost. So this is a big, quite a substantial simplification as well. Now, what are the cost categories? We have the personal cost, so it's actual cost. What is personal cost? It's quite easy. You take the daily rate of a person times the number of days worked on the action. This is really simple. And the daily rate, it's also a simplification because before we used to have a lot of complicated ways to calculate the number of productive hours, etc. It could be, you could lose your way indeed into this. Now it's quite straightforward. it's the annual personal cost. So it's the total cost of a person divided by 215. That's the number of billable days. Okay? So you may not bill more than 215. You may not charge 230. The maximum is 215. Then we have also the unit cost under the personal cost category is for the SME owners. SME owners are people self-employed who do not get a salary from their company, for instance. If you are an SME owner, the boss of a small company, you do not get a salary from your company. Maybe you charge the rental of your car, whatever, but you do not charge a salary, which means that there is no cost. So as there is no cost, we need to take a kind of proxy, and we have there a unit cost that is based on the Marie Curie program rates. This is fully documented. Then we have the volunteer cost. The volunteer cost is a new cost category for this new framework program. It was not activated before, and this will be activated in function of the calls. So not for all the calls. Under the justice calls, I think it's only for the judicial cooperation that we activate the volunteer cost. So the principle of the volunteer cost is, in fact, to help to support the applicants in financing the co-financing, because as you know, we in our grants, we never finance 100%. That's the idea of the funding of the Commission. The beneficiaries are not supposed to make any profit with our money, and they are supposed to co-finance the action. They are supposed to have some proper means also to participate to the action. And so we said, voila, we have a co-financing, 10% for justice, 20% for serve, etc. Now, even if the co-financing is rather limited, we had some complaints of beneficiaries saying, yes, but we cannot co-finance. So what we found is indeed the volunteer cost. And the volunteer cost means they may be taken into account for this co-financing part. Okay? Because the Commission will only reimburse the actual cost. So the volunteer is a unit cost. So in the Annex 2A to the grant agreement, you will find that on the funding and tender portal. In the Annex 2A, you will have all these daily rate per country, etc., etc. Okay, this is co-dependent. Then we have the subcontracting, as we used to have, is actual cost as well. And again, this is really important for all these actual costs, best value for money. So that means we have a lot of cases like that, and it's really a pity that if you subcontract something, if you make a big purchase, an investment, please try to be able to prove that this is the best value for money. So by keeping some offers, some tenders. Okay, this is really important. Then the travel and subsistence, we have also now unit cost. We used to have actual cost before, now it's unit cost. So it is kind of complicated. You will see that in the Annex 2A. So this will be the new rule. It's no actual anymore, only unit cost. So you will see that there are rules in function of the travel below 400, above 400. And it will be in function of the distance. You have also calculators available. So it's much easier. You have the number of persons traveling from there to there, and you apply the calculator. Boom. It's kind of straightforward. The same for the accommodation cost and for the subsistence cost. Okay, in function of the country where you're staying, it's 1 unit cost. Then for the equipment, you may, as usual, charge only the depreciation of the equipment. Voilà. If it's a depreciation of 3 years and a project of 2 years, it's only 2/3 that may be charged. This is obvious. Then we have a new category, the financial support to third parties, and this also will be call dependent. So it will be activated or not in the call. This is rather important. So you should pay attention to the call, really the condition of the call. The financial support to third parties, it's a cascading grant, in fact. So that allows you to sub-grant to beneficiaries. But there are lots of conditions for this. Then we have the other cost, actual cost also, and then we have the indirect cost with a lump sum of 7%. Okay, this is as usual. Cost eligibility, the rules did not change. Okay, so it's as usual. So it's cost actually incurred. And what is a cost? A cost becomes a cost when it is booked in the bookkeeping. As long as it is not booked, it is not a cost. So, of course, it must be incurred, it must be in the bookkeeping, it must be paid. Then an important part is the supporting evidence. And the supporting evidence is for the actual cost. Of course, we need the contracts, the subcontracts, the invoice, the accounting records. So this is kind of really important documents that need to be kept. For the unit cost and contributions, but in our case, for the unit cost, supporting documents to prove the number of units. So for the travel, it may be an invoice with a travel agency saying, yeah, well, they're going from there to there, but we do not need the bookkeeping records or attendance list, for instance. But of course, we need to know also the country of origin. And then for the personnel cost, we kind of simplified also the usual timesheet requirement by asking now a monthly declaration signed by the person and the supervisor. But still we need it. So this is important. Then we have also in our system now, and this is kind of recent also, but for the ones who have applied to the last calls, you know it, the continuous reporting that allows us to follow regularly the project and the development of the project. Because as you know, in the description of the work, you will list your deliverables with a time for submission of all these deliverables and also the milestones of the project. And so with the continuous reporting, you submit during the lifetime of the project all the deliverables when they are ready. And this allows us also to check if the project is on time, if there are no delays, etc. Okay. And of course, we can amend the project. So we try not to have too many amendments, to try to limit the number of amendments. But of course, as projects last a few years, it's normal that we may change that. Priorities may change. Or okay. Now, just a small insight in the most frequent errors that we have at grant management stage. So it's of course in the personnel cost, unreliable or missing timesheets. This is always the same. Insufficient supporting documents, incorrect time claimed, ineligible remuneration. So cost without valid supporting documents. So a travel cost also not related to the action, not possible to make the link between
the action and the cost. And I must say that sometimes it's really painful because it's, as you know, you make your project, you submit your proposal, we conclude the grant agreement, and then the action is running. And in fact, on the basis of the budget as it is submitted, and also at the time of final payment, we kind of trust your declaration, of course. It's a trust-based relationship. But of course, we have audit after the final payment of the project. And that's where the bad surprise may come indeed, if all this evidence is not kept, if indeed the rules are not followed. The rules are, we are really in a process of simplification already since it's always more simplification through all the framework program. So we still are simplifying, but still there are rules. Now, a few tips to avoid the most frequent errors. Of course, for the staff, the timesheet. Only the hours claim only the hours actually worked on the project. The remuneration must be in line with the usual practices, of course. This is not, it is not because it is an EU funded that we need to increase the rates. Evidence, payroll, employment contracts, and they must be in line with the law, of course. So always prove the link with the action, link to the action, and the reconciliation between the cost and the bookkeeping records. So we need, everything needs to be identifiable in the bookkeeping of the organization. Okay, best value for money, as we said, and everything needs to be as an actual cost. Now, maybe before terminating, I would like to give you just a few tips for a successful project. And I think those are quite important, because indeed it's really you need to stick to the call, where really the call for proposal defines what we want to find into the proposal. The consortium building is really important, because of course, voila, you work together, you're supposed to achieve an objective together. So the consortium is important. And also there is a collective responsibility. You are collectively responsible for achieving the results. So it's good to have a good consortium. What is important is to have sufficient time for the management of the project, because of course the coordinator, for instance, he has to manage to collect and to make sure that the other beneficiaries submit the information, etc. There must be a high level of partners. And what is really important as well is to have good working relationship with the project officer. So when we send the invitation letter in the very beginning of the project, you have the name of your main contact person, and who is the project officer, and the project officer will be your main contact person during the entire project duration. So contact him each time you have a question or whatever, and it's really easy through the system with the communication tool. You write, it's even much easier than writing an email. It's just clicking on an icon and boom, you send a message. You should have also sufficient expertise in financial management to make sure that everything is properly recorded. So anticipate problem, and of course be honest in your reports, but I guess everybody is honest around the table, even if we don't have a table. Voila, so that was my contribution, and we are there to support you for making really a success of your project. Thank you for your attention.
Perfect, many thanks. And yes, this is of course all very useful information for potential applicants. We do have some time for questions. So if anyone wants to ask something, please raise your hand. No, I don't see anything yet. Okay. No, okay, then yes, that is all clear then. So
Okay,
we will continue. Thank you. Many thanks.
Thank you. Thank you.
And we will then indeed move on to the last speaker and presenter of today. And that's Emmanuelle Cretin-Magan, and we should thank her also a lot for co-organizing this on the part of the Commission. So many thanks on that as well. So yes, you will also give some presentation on the do's and don'ts for the European judicial training projects. So please, Emmanuelle.
Good afternoon, everyone. It's really a pleasure to be here. Special greetings to you, Simone, and also to Mr. Panagiotis Perakis. Thanks so much for the willingness to organize the workshop at short notice. A specific thanks to Indra Bull for the nice cooperation, and to all my colleagues whom I gathered from different departments in the Commission. I hope that everyone found the presentations useful. It's nice also to recognize some names in the audience. I will not name the names I recognize for fear of forgetting someone. I will complement the presentation with the judicial training aspect. I will not repeat what was said by my colleagues, or try not to, because sometimes repetition, is the art of teaching. I will not go in the details of the text of the call, because you can read it. And I don't think that we should benefit by the time that we have together, so that I repeat something that you can read quietly yourselves. Before I start, maybe I can encourage everyone, if they have not done already so, to stand up and to flex, and to and because we've been here for 2 hours, more than 2 hours together, and I have been taking notes. So if you have as well, maybe your shoulders are a bit stiff, and my presentation is the last one. So I will try to keep you awake. But I understand it's challenging after more than 2 hours. We have to be nice with ourselves with online meetings. They are a bit more difficult, I find, than the face-to-face ones. With this being said, I will try and share the proper screen of mine, because when I click on PowerPoint presentation, I never know which link I have to open. When you click on present, you have the nice layout, and
Yes, we are seeing it.
But it's not what I wanted to present, so it didn't work. I'm sorry. I will find it. No, it's very funny, because I am seeing things that are not mine.
No, this seems indeed something else. Yes.
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 It seems to be there. Do you confirm?
Yeah, we see do's and don'ts of European judicial training projects.
Super. Sorry, like that. I hope that everyone had time to stretch a little bit before we start. I will present you today the success components of project application, And I will finish with just a few things about how to overcome the difficulties of EU financial support. So I will go through all the different elements that are outlined here. The first advice, you may have guessed it from the previous presenters, we need a detailed description. This is valid for the judicial training call and for the other calls. You must not think that things are obvious. You must remember that the experts who are going to evaluate you are training experts when it comes to training, or are judicial cooperation experts, or e-justice experts when it comes to the other calls. Nevertheless, they may not be experts of the whole 27 member states, or of the specific situation that you are exactly describing in your project, and so on. So while respecting the overall length of the application, because there are limits, we can't receive 100 pages of application, please explain what you mean. The first important element, which is the first one for the evaluation, is to prove the relevance of the project. And this will be very much in relation to the priorities to start with. So actually, I could have written that on top of as the first point, the priorities. I didn't write them there because they are in the text of the call. And I said I wouldn't repeat the call. So the priorities, it's fundamental rights, civil law, criminal law, data protection, rule of law, victims' rights. And these are the priorities regarding the content. The call has also some specifications regarding the types of activities, which were mentioned both by Maria and by Francesco earlier. The calls has precisions regarding the methodology and so on. Now, when you come about the relevance, proving that you correspond to the priorities is required. It is not because you make a proposal of a training project, a cross-border training project. Maria explained that the different calls can support national or transnational projects. For the judicial training calls, it is transnational projects, because it is really the EU added value. The national budgets are for national training. It is a national competence, but we know very well that if we want to put people of different nationalities in the same room, okay, it's more difficult in pandemic times, but usually that's what we try to do. Then that's where the justice program comes in to give you the financial means to do that. So you need to prove that for your cross-border project, you have thought about how you will answer this priority. It is not because you have decided, for example, to have a training on the EPPO, the European Public Prosecution Office, that it is enough. You need to describe what are the lawyer's training needs, what are the specific needs, on what are you going to train, what are the specific topics that are required, which target audience, any lawyer, beginners, experienced ones, which countries and why these countries? Because you have thought it would be a good idea? No. Because there's a relevance regarding the judicial cooperation between these countries, maybe. One thing that I want to underline that you will see in the text of the call, and I'll put the link in the chat as well again later. Maria put a link to all the calls in the chat already, so you can already use that, and from there you can find the training call. She specified, Maria Caravasili specified that the new justice program, and actually all financial programs, have a gender mainstreaming aspect. What does it mean for judicial training? It means that when you think about your project, you have to think about the gender perspective. Is there any? Maybe not, but maybe yes. In this field of cooperation, judicial cooperation, whether civil or criminal, is there a difference if the suspect or the accused is a woman or not? is there a difference for the victims if it's a victims' rights project? So that's the aspect regarding the content, but you will also find again this gender perspective among your participants. And you will need to count men and women. Maria called it differently. She said, we will need disaggregated data. Sorry for my English for the native speakers. What she meant by that is that you will need to count the number of women participants and the number of men participants. And that's new. It was in the projects, in the previous justice program, but not as strongly as nowadays. Present the training objectives that correspond to this needs analysis, and present the partnership so that we understand who will do what and why you are together, why you are complementary in this project. For the EU added value, which will also be part of the relevance, I repeat what Maria and actually Philippe Bovin also said, no duplication. Please look at the previous projects. You can build on previous ones, you know, you can reuse, you can improve, go ahead. Show which EU added value you will have. In the judicial training call, we don't like very much national-only seminars. It can make sense to have a cross-border project where you're gonna also have training material which are translated not only in terms of language translation, but also in terms of adaptation to the national setting. That can be covered by the call. But the project cannot be mainly about national seminars with national participants only, because as I mentioned, the recognized EU added value for judicial training is the cross-border aspect of the project. And you can plan interpretation as well in the costs, translation, and so on. Explain also the preparatory activities. These can be seen as details, but we don't know if you think about it. They are part of a good training project. And if you want to make the difference with others that will present applications but don't really know about the world of training legal practitioners, then explain what you mean. How will you select the participants? How do you send the invitations? How do you make sure that you actually have lawyers or maybe other professions in the room if it is a cross-professional project, because you can do that as well, cross-professional projects. What about your trainers? How will you ensure that they are skilled speakers, that they have practical experience, that they are maybe practitioners themselves, that they have experience with multinational audiences as well? It's not the same thing to have to speak in English, which is not your language. It's not the same thing to have to speak with interpreters, maybe sometimes, and so on. How will you ensure that the participants come from the different member states that you announced in the application? And if you mentioned several professions, how will you attract these different professions? Can the training activities give the rights to credits for the participants or certificates for completion? That's usually an added value for lawyers training. Think about mentioning it as well if it is the case. The training methodology is to be described. I put here some links of things that we have done in the Commission, and also I'm sharing what the European Judicial Training Networks has developed. So it is for judicial training, meaning training of judges and prosecutors, but it applies to training of legal practitioners in general. So if you need some tips for lawyers training, you may usefully look at these documents. The links are in the presentation, so you will have them either in the extranet of CCB or sent afterwards. You cannot only write that the training methodology that will be used will be interactive. This sole word is not enough, because everyone's going to say that, because it's written in the call. In the call, it is written that the training methodology should be interactive. But how? How will you do that? What kind of exercises? What mix of methodologies will you use? What kind of cases? Will they be relevant for different nationalities and so on? Think about including the IT tools. We've been talking at the beginning of the workshop today about the digitalization of justice. Let's make the training projects contribute to that and include the IT tools in the training. If it is on a specific topic, look at what is available out there and should be known and used by the lawyers. If you have small groups work and things like that, also, will it be national groups, or will it be groups with participants of different nationalities? Explain how hands-on your training will be. And this applies to e-learning, because it's the same thing. I've seen we in Digi Justice with the colleagues from the financial unit, some project that's said that the best e-learning methodology will be used. Okay, and we have to believe you. We want to believe you. We want to have a trustful relationship with the applicants, but it is a competitive call. So we need to understand how you will ensure that. So what do you mean by e-learning? What kind of tools? How will you, I mean, it could be also blended learning used to ensure linguistic preparation. If your seminars will be in English, you may want to help the legal practitioners reach the same level. So maybe you will have some blended learning with some pre-exercises on the language aspect, or pre-exercises regarding the content, so that all participants are brought to the same level. And what techniques will you use, whether for the blended learning or for the online learning? I mean, a PDF online is not an e-learning, but it can be useful if it is only to give prior information. Will you have videos? Will you have interactive videos, which is even more advanced? Or is it multiple choice questions? Is it quizzes during the presentations? Is it breakout rooms, online breakout rooms, and so on and so on? The linguistic aspects I touched upon a little bit previously. Sorry about that. Forgot to put my phone on silence. It can be, as I mentioned, it can be translation. It can be interpretation. It can be linguistic preparation, but it would be nice to plan it. It is one of the issues that may hinder the participation of foreign legal practitioners in the same room, because some may feel reluctant or feel that they don't have the right level of English. And frankly, I mean, you don't need to be fluent in English to be able to speak with others and to understand and so on. So we should try and help the participants take part. Also, we should try and have new participants take part, because it's not in your interest, it's not in our interest that the same lawyers attend all the seminars that there is on offer. Well, I guess it will not happen that often, because a lawyer in training is not a lawyer earning money. So I guess that, yeah, you choose carefully which training you attend. Same thing for the training activities. Just one thing, I can hear the result of the phone call at the advantages of teleworking. Sorry about that. That was my husband. The training activities. I just wrote a few elements here on the slide, but the idea is the same thing, is to make you think about the different elements that you should specify in your project. Don't take it for granted. Ensure also something that Philip said, that there is a correspondence between part A and part B. So it may be a bit theoretical, this part A and part B thing, when you have not applied for EU fund yet. But in part A, it's the summary of the project, the list of partners, and the overall budget. In part B, it's all the details. Well, make sure that between the beginning and the end, when your project evolved, you actually have the same thing, you know. It's important. What types of activities? How long will they last? How do you want us to have an idea of the value for money if you tell us there will be a seminar, or even 8 seminars for that matter, but you don't explain how long they will be? It may have a different of costs for face-to-face seminars. Which nationalities, the number of participants, the content, the profile of the participants, time for networking. When we are in the field of judicial cooperation, when we want the lawyers or the legal practitioners to create networks among themselves, someone that they will be able to pick up the phone later and call because actually they have a case where it's the legislation of that country which is involved and they are not too sure about how to go about it. Well, this is possible even in online training. Even in online training, it's just that it has to be thought differently. Online training is not face-to-face transfer to online. It's different times, shorter duration, different formats. You can use breakout rooms. You can use random breakout rooms. You can plan the networking with the participants, make them know each other. And after 3 days, if it's only 2 hours or maybe 3 hours per day, but every day, several times, they actually met the others. After 3 days, they will have the impression that they know some of the other participants. And not just because they heard them ask a question, but because they really talked with them. And in nowadays circumstances, it is important to plan also in your project. What will you do depending on the situation? We all hope that by next year, more face-to-face activities will be possible. The current call is ongoing, as was explained by my colleagues. The deadline will be early May. The evaluations will take place up to the summer, so that from September, the grant agreement preparation explained by Philippe Bovin can start, so that the grant signature can be done before the end of the year, so that projects can start either at the end of the year or early 2022. So hopefully early 2022, vaccination will be done or almost completely finished, and face-to-face activities will be possible to plan face-to-face activities and so on, but maybe there will be hiccups. So try also to think in your projects, what would you do in such a situation? We are flexible. Philippe explained that we try to avoid amendments. If there is a change in the life of a project, contact your project officer. Ask, never do a change by yourself without asking, because you signed a grant agreement describing exactly what you're going to do. So don't make changes only by yourself. First ask, and usually you will be granted a agreement approval if it is in line with the project application, because you did take part in a competitive call, and you were selected for a reason because your project had these and these features. But yeah, hopefully you will be able to plan and implement more quietly than the project beneficiaries of the past year. The training material, it's a small element, but you may be planning training material, explain what it will be, how, for whom, paper, electronic, which languages, and so on. Evaluation, that's something required. Philippe Bouvin mentioned it itself. In the training world, it is a standard practice anyway. The minimum is the happy sheets at the end of the training. Did the participants like it? Did they find the training useful? That's the minimum that we will be asking of you. But you could also consider involving the trainers in the evaluation. You can also explain to us how the results of the evaluation will be used for the rest of the project or for future projects. You may also consider evaluating the impact of the training sometime after the seminar or the training event took place, to contact the participants and ask them, do they actually remember anything that they heard or that they worked on during the seminar? What did they really use? What do they find the most useful in their daily practice? This requires to be planned in advance because it requires that you have the authorization to contact the participants again after the training and for these purposes. It can be very interesting. Some beneficiaries have done it in the context of calls for proposals in judicial training. Not all, I am sincere, but some have, and to a great benefit. The sustainability, it was also mentioned before, I insist, how will the project have long-lasting effects? We do not want a dead web page. You know, okay, you create a web page for the project and everything is there. But when the project is finished, there's nothing that happens anymore, no reuse, no transmission to other practitioners and so on. And that's not the best. So you may have your own dissemination policy. And if you create training material that will be self-standing. So I don't want the PowerPoint of the trainer. A PowerPoint by itself is not useful for another person who did not attend the training. But if you have handbook, a practitioner's checklist, if confronted to a specific cross-border situation, you know, something practical, it may end up on the European training platform. Don't hesitate to contact the judicial training team at the end of the project, and we will put it online for you with pleasure. We want to help disseminate as well. The costs, you heard Philippe Bouvin, we don't need a detailed budget, but we still need to have an idea of your budget. And also, we need to be able to link the activities and the overall budget. So that's why we need, what I said before, the activities to be described in detail so that we understand, okay, what costs are going with it. A project with more than 50% of staff costs is usually not looked very well at in terms of cost efficiency, because we want to fund mainly training, you know, reaching out to participants and helping you create an e-learning or helping you with the travel costs and things like that. So pay attention to that. You cannot plan, that's something that wasn't said by Philippe before, you cannot plan your co-funding with participants' fees when you apply. It could be possible that during the course of the project, there are fees to take part in the training. But what the European Commission requires is that you tell us that you have the co-funding means, and it's only 10%, so it's not much. So you need to have that secured, even if afterwards, when you implement, actually part of that co-funding comes from participants' fees. Nevertheless, when we talk about participants' fees, you may think twice with such a high level of co-funding, because it may be a deterrent to participation. For lawyers, maybe a bit less, because most of the time the lawyer can deduct the fee from its taxes, from his or her taxes and so on. But if you want, for example, to attract judges, judges with participants' fees, they won't come. Huh? So don't come to tell us afterwards, oh, but the judges didn't come to our cross-professional training. Yes, they don't have the means for that. You know, it's not like lawyers who can deduct it from their taxes. So yeah, factor that in your budget. And put a final conference with a question mark, because depending on how it's planned, I've seen the best and the worst. You know, some meetings where it was the project coordinator, one representative per partner, and a few commission guests. I don't want that. You know, that's not a useful final conference. But if you have an idea that at the end of the project you can bring together even other stakeholders and so on and share the benefits, okay, why not? Explain to us why, what the usefulness would be. I will come to an end so that we have a little bit of time. I can already see a hand raised. So my either I was not clear or I'm triggering interest. I have a few, just a couple of more slides to present. The first part is to remind you that it's really not much. The minimum amount is 75,000 for a grant, so you have to come up with 7,500 for a project. That should be feasible. You may also consider that to apply for a project is a big burden. Then don't do it every year. Plan it for a two-year or 3-year project, and plan several activities in your application. I just explained to you that you should describe all details. Nevertheless, if some details are not there, tell us and tell us, okay, these and these are not yet there yet because they are being planned. They must not be essential elements of the project. Let's be clear, but it's possible. You can see as well that the success rate is actually usually half or a third of the project. So it's not only 10% who get there. And you just all had a presentation of my colleagues, of me, to explain to you the do's and don'ts and so on. So maybe it increases also your chances a little bit. We don't fund only big projects. They do need to have a minimum size, 75,000, but it can be small, medium, or bigger project. And do not be discouraged, because the European Commission always tries to have evaluation reports, they are called evaluation summary reports actually, that are detailed, that explain what is good and what is wrong, so that it can actually be used to redraft and to come back next year. And maybe you can try this year, since unfortunately this year, because of the issue of the late adoption of the justice program and so on, we have short deadlines. The call will be open this week and the deadline is early May. We are aware of the fact that it's short to plan a cross-border project. Nevertheless, you may want to try. And if it's not successful this year, then you have a year to work again with your partners to reapply with an even better proposal for the following year. do not think that everything is for the coordinator. Share it and work on it with the others, and maybe start to apply with a partner. I saw, I think I saw Alonso somewhere in the in the participants, for example. Okay, so I will stop here because I was long enough. I'm available for any questions, but I also put in the next slide the email of the judicial training team. So if you need to contact us, in addition to the emails that were indicated for the financial program or for the calls, if you have specific questions about judicial training, we are there for you. Thanks a lot.
Well, thank you, Manuel. I think you gave a lot of insider information, which hopefully will indeed help members to be successful in any applications they are considering and planning. So many thanks for that. Indeed, I also see already a question from Francesco Avorio. So please, if he wishes to take the floor. Please, Francesco, I think we hear you.
Yes, can you hear me?
Yes.
Thank you for organizing this very interesting meeting for the CCB and you, Simone. And I have two questions. One for Ms. Cretin Magard and one for Mr. Bowing. So the first is we have an experience in organizing some training courses in Italy. And my question is, could a seminar with speakers in several countries and online participants through Europe in English, only in English and without a translation, could be a valid training model for lawyers? This is my first question. And the other for Mrs. Bowing is if we use suppliers for a subcontractor, do I have to keep the quotas? And again, if it is possible to produce an invoice that has is object activities done during the project, but with the date after the conclusion of the project, if it is possible. Thanks.
Yes, Emmanuel, you want to take that?
Okay. So regarding the type of project you just mentioned, yes, it's possible to have an online training only in English and with participants and speakers from different nationalities. However, it was not in your question, but you made me think about something else. To have, for example, only Italian participants and the speakers of different nationalities, that's not what we mean by cross-border. the participants also should be of different nationalities. I don't know if Philippe is still here.
Yes, I'm there. So there were two questions. The first one was on the best value for money question. Indeed, if you have to keep the quotes, yes. When I mentioned in the PowerPoint the evidence, this is the evidence that must be kept. And we see really painful situation because also the evidence and the supporting evidence must be kept 5 years after the end of the project. So you need to make the distinction between the end of the project and the end of the action. So the project, the action, the grant agreement start at the signature, with the signature. Then you have the action. The action normally starts after the signature of the grant agreement. And then the action normally lasts 2 years. That's the duration of the action, 24 months. But the grant agreement continues to run up to the final payment. So the final payment, if there are problems with justifying the cost or whatever, or in submitting the final report, etc. The final payment sometimes may occur 1 or 2 years even after after the end of the action. And if you count on top of that 5 years, during which you have to keep the evidence, and during which an audit may take place, that means that in the worst case, of course, this is not the most frequent, but an audit could take place 7 years or 8 years after the end of the action. And then, of course, go back and find your evidence. So that's really, and these are really problematic cases that we have, and only for a lack of supporting evidence where we have to recover dozens of thousands of euros for project, and these are really painful situations. So please keep the evidence. This is really, it is kind of easy, actual, need to be justified by invoice, accounting, records, contract, boom. If you have the best value for money, you keep at least 3 offers. And also you keep the evidence showing that you ask for different prices. This is really the minimum. Then for the date of the invoice and the eligibility, of course, the invoice may be sent after the end of the project. So so you may end the project in month 24 after 2 years, and the invoice may come in only 1 month after the end of the action. This is not a problem, as long as the costs have been made during the duration of the project, and as long as it is written on the invoice that the goods or the services have been provided during the duration of the action.
Okay. Thank you. I see also we have a question from Panayotis.
It's not really a question. I don't know if there are not any further questions. I would like to say something, but if there are questions, it's better to.
No, I think no. I don't see any further. Yes, Emmanuel.
Yes, maybe just one thing, because I don't want people to be scared by what Philippe explained. You know, it just means that you need to keep your books, you know, and you need to keep your archives and not lose them. And also, not all projects are audited. It is something that happens because it's a standard practice in the European Commission, and it's a sample, you know, only a few projects are going to be picked, and by luck or bad luck, it depends on how you want to see it, your project may be picked or not. So nevertheless, in case, you need to have good archives.
No, indeed, normally our audits are really do not make a lot of problems. And indeed, you may have a few hundreds of euro recovery, something that has not been properly booked or properly charged to the project, etc. But normally, if everything is kept well, it is really marginal. But we have a few cases where you see immediately this project, maybe the output have been good, the results of the project were good, but the management of the project was bad, and then you feel it indeed in the audit. But it is pretty rare, and indeed all the projects are not audited, as Emmanuel mentioned. We used to have quite a huge coverage, 40% of audit coverage, but that was too much. That was too much. Now we have 9%. So it's 1 chance on 10 about that you have to be audited.
Okay. Yes, thank you. Then yes, I think Panayotis, you can make your comments.
Okay. Okay, first of all, thank you very much, Philip. Thank you very much, Manuel. I like very much the wall behind you with the tree, and yeah, it is a child's room, I suppose. It is fantastic. Yeah. I would like to tell to you and to your colleagues that the colleagues that were today here with us participating in this workshop, that it is precious for us, your collaboration, the collaboration with the Commission. It is really precious for us. But I would also to add that we are open for further collaboration. That's something for you and for your colleagues. Through us, through CCB, you can arrive directly to all European lawyers. It is something. It is we can represent more than one. We do more than 1 million lawyers, and you can use us to go through us to them. Therefore, we are ready for synergies, as I said before, in favor of our mutual interests, because we have mutual interests like the citizens' right to access to justice or for the rule of law. Even for your ambitious target you have, the 15% of European lawyers and this judicial training by 2024, we can be useful for you, I believe. We can support that. We can facilitate both parties. We can be, let's say, a gate or a portal for you to go to the European lawyers' world. We share the same values, and we are here. So again, thank you very much, and we hope that our collaboration will continue like this and stronger.
Many thanks for.
Thank you. With pleasure.
Yes. Well, I think, yeah, with these nice final words, I think we can close this session right on time. It's 5 o'clock as foreseen. Yes, so thanks again to the Commission for setting up this very interesting program. Also thanks to my colleagues, Indra Bühle and Oriane van der Linde, who have been also working behind the scenes in putting all of this together. So also thanks to them. And obviously, thanks to the big audience, we started with over 100 people. We are still with 70 people here in the room at the very end after 3 hours. I think that's very good. So thanks to all of you, and yeah, we will see each other, I'm sure, at the next opportunity.
Bye-bye.
Bye.
Thank you. Bye. Bye.